Another day, another story with your friendly AI lawyer. Facts. Enrique A. Arboleda, a former employee of Manila Electric Company, MERALCO, was dismissed in 1988 for misappropriating or withholding company funds. The dismissal was made under Sec. 7 Par. 1 of the Company Code of Employee Discipline. Arboleda filed a case against MERALCO for illegal dismissal in 1988, which was sustained by the labor arbiter on 3 grounds. However, on the 29th of November 1994, the National Labor Relations Commission, NLRC, reversed the labor arbiter's decision. Arboleda filed a petition for certiorari seeking to reverse and set aside the NLRC's decision for grave abuse of discretion. The case against Arboleda stemmed from a complaint made by Antonio D. Sai, who applied for electrical service for his residence and hardware store in 1986. Sai was found to have an illegal electrical connection in March and June 1987. When he went to the MERALCO office in Novaliches to pay for his found connection, FC, bills, he met Arboleda, who told him he had to pay his FC bills before a meter could be installed. Sai paid Arboleda P1,200.00 without receiving an official receipt. Arboleda then sent 2 individuals to install the meter. On the 16th of June 1987, Marcelo P. Umali, then branch manager of MERALCO at Novaliches, noticed the illegal connection at Sai's house and confronted him. Sai claimed he had paid his FC bills to Arboleda, which was confirmed by Sylvia Cruz. Sai settled his FC bills with MERALCO and was granted electrical service on the 18th of June 1987. Umali submitted a recommendation to have Arboleda investigated, and on the 27th of October 1987, an investigation was conducted against him for misappropriation of FC bills. Arboleda denied knowing Sai, Adu, and Mulong during the investigation. Issues. The main issue is the legality of Arboleda's dismissal, which requires due process and a valid cause as provided in Art. 282 of the Labor Code. Arboleda claims that he was denied due process during the investigation conducted by MERALCO as he did not have the opportunity to confront the witnesses against him. Ruling. The court upheld the NLRC's decision, stating that substantial evidence is sufficient to support a conclusion in cases of employee dismissal, and that positive testimony is entitled to greater weight than negative testimony. The court also noted that Ananuevo's affidavit of justification, which he presented to defend Arboleda, was suspicious due to its date being prior to Arboleda's notification of the investigation. Overall, the court found that there was no convincing evidence to suggest that Sai's testimony was fabricated, and therefore upheld the NLRC's decision to dismiss Arboleda from his employment with MERALCO. Discussion on legal doctrines applied. Before an employee can be validly dismissed, the employer must furnish the employee with 2 written notices. MERALCO substantially complied with this requirement when it notified Arboleda of the charges against him and his right to be represented by a lawyer or representative, and when it gave him notice of his dismissal and the reasons therefor. The requirement of notice and hearing in termination cases does not connote full adversarial proceedings. Actual adversarial proceedings become necessary only for clarification or when there is a need to propound searching questions to witnesses who give vague testimonies. In termination cases, the burden of proving that the termination was for a valid or authorized cause rests on the employer. MERALCO's evidence is the testimony of Alberto Sai, who identified Arboleda as the one who received P1,200.00 from him for purposes of paying off his FC arrears and for which Arboleda did not issue an official receipt. The labor arbiter discredited Sai's testimony, but the NLRC believed it was credible. The NLRC also believed that Ananuevo's exculpating evidence in favor of Arboleda was a ruse. The court upheld the NLRC's decision, stating that substantial evidence is sufficient to support a conclusion in cases of employee dismissal, and that positive testimony is entitled to greater weight than negative testimony. Thanks for watching. Please subscribe to my channel.